Hello and welcome to Study with Sri. Here I am discussing Indian polity by M. Lakshmikant chapter wise. So today's topic is conflict between fundamental right and DPSP. So stay tuned and watch this video. The justiciability of fundamental rights and non-justiciability of directive principles on one hand, and moral obligation of state to implement directive principles, that is article 37, on the other hand, have laid a conflict between the two since commencement of the constitution. Okay, we know that fundamental rights are justiciable in nature and DPSP are non-justiciable in nature, and they are on one hand and moral obligation of state to implement the directive principles on other hand have led to conflict. So first case is Champakam Dorairajan versus State of Madras 1951. So here the Supreme Court ruled that in case of any conflict between fundamental rights and DPSP, the former would prevail. Okay, so कोई भी अगर conflict होगा fundamental rights and DPSP के अंदर, then former would prevail. It declared that directive principles have to conform to and run as subsidiary to the fundamental rights. Okay, so but it also held that fundamental rights could be amended by the Parliament by enacting Constitutional Amendment Act. Okay, as a result, Parliament made the First Amendment Act 1951, Fourth Amendment Act of 1955 and Seventh Amendment Act of 1964 to implement some of the directives. Clear? So, Supreme Court ruled that fundamental rights could be amended by the Parliament by enacting Constitutional Amendment Act in the case of Champakam Dorairajan case. The above situation underwent a major change in 1967. 1967 में क्या हुआ ना, Supreme Court judgment in the Golaknath case versus State of Punjab 1967. So in that case, Supreme Court ruled that Parliament cannot take away or abridge any of fundamental rights which are sacrosanct in nature. Okay, so जो Champakam Dorairajan केस में बोला गया था कि Parliament can amend the fundamental rights. Okay, Parliament it also held that fundamental rights could be amended by the Parliament by enacting Constitutional Amendment Act. But Golaknath case में क्या बोला गया है कि Parliament cannot take away or abridge any fundamental right which is sacrosanct in nature, and in other words, the court held that fundamental rights cannot be amended for the implementation of डायरेक्टिव प्रिंसिपल. सो फंडामेंटल राइट को अमेंड नहीं कर सकते फॉर द इम्प्लीमेंटेशन ऑफ डायरेक्टिव प्रिंसिपल. द पार्लियामेंट रिएक्टेड टू द सुप्रीम कोर्ट्स जजमेंट इन गोलकनाथ केस 1967 by enacting 24th Amendment Act 1971 and 25th Amendment Act of 1971. 24th Amendment Act declared that Parliament has the power to abridge or take away any of fundamental rights. Okay, so Supreme Court Golaknath case में बोला था कि Parliament cannot take away or abridge any of the fundamental rights. But 24th Amendment Act में Parliament amend किया कि Parliament has power to abridge or take away any fundamental rights enacting by Constitutional Amendment Act. Okay, 25th Amendment Act inserted a new article, that is 31C, which contained the following two provisions. So, in the article of 31C, it says that no law which seeks to implement the socialistic directive principles specified in article 39B and 39C shall be void on the ground of contravention of fundamental right conferred by Article 14, that is equality before law and equal protection law, Article 19, protection of Sikhs' rights in respect of speech, assembly and movement, and Article 31, that is right to property. Now Article 39B. आर्टिकल 39B में पहले आर्टिकल 14 समझना होगा. आर्टिकल 14 says that equality before law and equal protection of law. Okay, and article 39B suggests that article 39B says the state shall direct its policy towards securing that the ownership and control of material resources of the community are so distributed as best to subserve the common good. ओके, आर्टिकल 39B में बोला गया था कि द इक्विटेबल डिस्ट्रीब्यूशन ऑफ मटेरियल रिसोर्सेस ऑफ द कम्युनिटी फॉर द कॉमन गुड. ओके, सो इक्विटेबल डिस्ट्रीब्यूशन मतलब क्या है? इक्विटेबल डिस्ट्रीब्यूशन, सपोज एक रिच इंसान है एंड एक पुअर इंसान है, ठीक है, एंड मेरे पास 100 रुपीज़ है. इफ आई गिव देम 50 रुपीज़ देन इक्वल डिस्ट्रीब्यूशन. बट इक्विटेबल डिस्ट्रीब्यूशन इज इफ आई गिव द रिच पर्सन 20 रुपीज़ एंड द पुअर पर्सन 80 रुपीज़, देन इट इज कॉल्ड एज इक्विटेबल डिस्ट्रीब्यूशन. सो state shall direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. Okay, it is conflict with article number 14, like equality before law and equal protection of law. Okay, article 39C says that state shall direct its policy towards securing that the operation of economic system does not result in concentration of wealth and means of production to the common detriment. मतलब कोई भी एक पर्सन, कोई भी एक मतलब पर्सन में कंसेंट्रेशन ऑफ वेल्थ नहीं होना चाहिए. ओके, एंड मीन्स ऑफ प्रोडक्शन टू कॉमन डेट्रीमेंट. सो these rights are conflict with the article number 14, article number 19 and article number 31. So it says that no law which seek to implement the socialistic directive principle, कोई भी law अगर implement करना चाहता है socialistic directive principle specified in 39B, that is equitable distribution of material resources of the community for common good, and 39C, that is prevention of concentration of wealth and means of production, shall be void on the ground that of contravention of fundamental right conferred by 14, 19 and 31. Okay, no law containing a declaration for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such policy. So कोई भी law ऐसा नहीं है containing a declaration for giving effect to such policy that shall be questioned in any court. So judicial review से ही ये लॉ को बाहर कर रहा है कि कोई भी लॉ कंटेनिंग अ डिक्लेरेशन ऑफ गिविंग इफेक्ट, अगर इफेक्ट मतलब कोई भी लॉ का अगर इम्प्लीमेंटेशन हो रहा है टू सच पॉलिसी शैल बी क्वेश्चन इन एनी कोर्ट, देन कोई भी कोर्ट पे कोई क्वेश्चन नहीं कर सकते ऑन द ग्राउंड दैट इट डज नॉट गिव इफेक्ट टू सच ए पॉलिसी. सो इन केशवानंद भारती केस versus Union of India 1973, Supreme Court declared that the above second provision of Article 39C का जो इसमें बोला गया था no law containing declaration for giving effect to such policy shall be questioned in any court, the judicial review से बाहर कर रहा था, ठीक है, as unconstitutional and invalid on the ground that judicial review is a basic feature of the constitution, hence cannot be taken away. Okay, judicial review क्या है? Basic features of the constitution. So ये जो second provision है declared as void. However, above first provision of Article 31C was held to be constitutional and valid. Okay, latter 42nd Amendment Act 1976 जब आया extended the scope of the above first provision of Article 31C by including within its protection any law to implement any directive principles, not merely those specified Article 39B and 39C, 39 clause B and 39 clause B. C. In other hand, in 42nd Amendment Act accorded the position of legal primacy, accorded किया the position of legal primacy and supremacy to the directive principle over the fundamental rights conferred by Article 14, 19, 31. मतलब आर्टिकल 39 क्लॉज बी एंड 39 क्लॉज सी को ज़्यादा प्रायोरिटी दिया गया देन आर्टिकल 14, 19 and 31, that is fundamental rights. However, this extension was declared unconstitutional and invalid by the Supreme Court. Okay, in Minreva Mill case. Okay, Minreva Mill case में क्या हुआ ना, ये जो डिक्लेरेशन था वो इनवैलिड हो गया, ठीक है. एंड केशवानंदा भारती केस एंड स्टेट ऑफ केरल वर्सेस स्टेट ऑफ केरला में क्या था ना, जो 31 सी का जो सेकेंड प्रोविजन था, दैट इज no law containing declaration giving effect to such policy shall be questioned in any court on the grounds that it does not give effect to such policy, ये invalid हुआ था, ठीक है. एंड 31C का फर्स्ट प्रोविजन क्या था, वैलिड था. बट मिनर्वा मिल केस में क्या हुआ, मिनर्वा मिल केस में वर्सेस यूनियन ऑफ इंडिया 1980, सुप्रीम कोर्ट रूल्ड दैट डायरेक्टिव प्रिंसिपल्स वर वंस अगेन मेड सबऑर्डिनेट टू fundamental rights. It means that directive principle, however this extension was declared unconstitutional and invalid by Supreme Court in Minreva Mill case. It means that directive principles were once again made subordinate to fundamental rights, but fundamental rights conferred by Article 14 and Article 19 were accepted as subordinate to directive principle specified in Article 39 clause B and 39 clause C. Further, Article 31, right to property, was abolished by 44th Amendment Act of 1978. Okay, so here 42nd Amendment Act 1976 extend किया the scope of the first provision of Article 31C by including within its protection any law to implement any directive principles, and not merely these specified in Article 39 clause B and 39 clause C. In other words, the 42nd Amendment Act accorded the position of legal primacy and supremacy to the directive principle. तो 42nd Amendment Act क्या किया ना, position of legal primacy and supremacy of directive principles over the fundamental rights conferred by Article 14, 19 and 39. However, this extension जो था ना वो unconstitutional and invalid बोला गया है in by the Supreme Court in Minerva Mill case versus Union of India 1980. So it means that directive principles were once again made subordinate to fundamental rights. Okay, again directive principle को सबऑर्डिनेट कर दिया गया था फंडामेंटल राइट्स में, बट फंडामेंटल राइट कन्फर्ड बाय आर्टिकल 14 एंड 19 वर एक्सेप्टेड एज सबऑर्डिनेट टू डायरेक्टिव प्रिंसिपल स्पेसिफाइड इन 39 क्लॉज बी एंड 39 क्लॉज सी. 14-19 में जो है उसको सबऑर्डिनेट कर दिया गया था आर्टिकल 39 बी एंड 39 सी का. फर्दर आर्टिकल 31 राइट टू प्रॉपर्टी वॉज एबोलिश्ड 44th Amendment Act of 1978. In Minerva Mill case, very important case, ठीक है, Supreme Court ruled that the Indian Constitution is founded on the bedrock of balance between fundamental rights and directive principle. Indian Constitution जो है ना वो फाउंड किया गया था on the bedrock of the balance चाहिए fundamental right and DPSP के अंदर, ठीक है. They together constitute the core of the commitment to social revolution. Okay, they together constitute the core of commitment to social revolution. They are like two wheels of a chariot, one no less than the other. Okay, so to give absolute primacy to one over the other is to disturb the harmony of the constitution. If you want to prioritize one over the अदर देन हार्मोनी ऑफ द कॉन्स्टिट्यूशन है उसका बैलेंस जो है दैट विल बी डिस्टर्ब्ड. सो दिस हार्मोनी एंड बैलेंस बिटवीन द टू इज एसेंशियल फीचर्स ऑफ द बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन. ठीक है, द गोल सेट आउट बाय डायरेक्टिव प्रिंसिपल हैव टू बी अचीव्ड विदाउट एब्रोगेशन ऑफ मीन्स ऑफ प्रोवाइडेड बाय फंडामेंटल राइट. जो गोल सेट आउट बाय डायरेक्टिव प्रिंसिपल में है have to be achieved without abrogation of the means of provided by fundamental rights. Therefore, the present position is that fundamental rights enjoy supremacy over directive principle. Yet, this does not mean that directive principle cannot be implemented. The Parliament can amend fundamental right for implementation of directive principle. Okay, so Champakam Dorairajan case में जो था कि Parliament cannot amend the fundamental right for implementation of directive principle, ये change कर दिया गया and Parliament can amend fundamental rights for implementation of directive principle so long as the amendment does not damage or destroy the basic structure of the constitution. Okay, so clear? Now you can see the distinction between the fundamental rights and directive principles. So fundamental rights, these are negative as they prohibit the state from doing certain things. Okay, fundamental rights are negative as they prohibit the state from doing the certain things. But directive principles are positive as they require the state to do certain things. Fundamental rights are justiciable, that is, they are legally enforceable by the court in case of their violation. If fundamental right का violation हो जाए तो fundamental rights are justiciable, right, and legally enforceable by the court. But DPSP are non-justiciable, that is, they are not legally enforceable by the court for their violation. Fundamental rights aim at establishing political democracy in the country. ये क्वेश्चन बार बार आता है, ठीक है, कि fundamental rights aim at establishing political democracy in the country and DPSP aim at establishing social and economic democracy in the country. Fundamental rights have legal sanction and DPSP have moral and political sanction. ये भी बहुत important है. Fundamental rights have legal sanction and DPSP have moral and political sanctions. The fundamental right promote the welfare of individual, hence they are personal and individualistic. But DPSP promote the welfare of the community, hence they are societarian and socialistic. Fundamental rights do not require any legislation for their implementation, they are automatically enforced. Okay, so fundamental rights do not require any legislation for their implementation, they are automatically enforced, but DPSP require legislation for their implementation, they are not automatically enforced. Fundamental rights, the courts are bound to declare a law violative of any fundamental right as unconstitutional and invalid. So court are bound to declare a law violative. कोई भी law है, court are bound to declare this law as violative of any fundamental right as unconstitutional and invalid. The courts cannot declare a law violative of any of the directive principle as unconstitutional and invalid. However, they can uphold the validity of a law on ground that it was enacted to give effect to a directive. So, the court cannot declare a law violative. Court declare नहीं कर सकता है कोई भी law violative है of any of the directive principle as unconstitutional and invalid. Okay, so court cannot declare a law violative of any of the directive principle as unconstitutional and invalid. However, they can uphold the validity of a law on the ground that it was enacted to give effect to a directive. Okay, clear? So, thank you for attending this session. Stay tuned for next session. Thank you.